Hi there, this is Jonathan Ginsberg. I'd like to talk to you today about continuing disability reviews. As you may know, when you are approved for disability benefits, Social Security retains the right to review your case down the road to see if you remain disabled. And what we're seeing now is that when judges approve cases, they will typically approve it and will indicate whether the review needs to be in 3 years, 5 years, or 7 years. If it's a 5 or 7 year review, that usually means that the judge feels that your disability is likely to be permanent. If it is a 3-year review, then that means the judge feels like you possibly could be seeing some improvement down the road. And it's really important to know which type of review you have in your decision, because that really will help dictate what you should try to do in terms of your ongoing treatment. You should still get ongoing treatment, but I think if you're in a 3-year review case, we're going to see a lot more reviews. I think what's happened is that Social Security has made a big effort for the past few years to try to encourage judges to really only approve cases where the evidence is compelling. What they found is that judges really resented the intrusion on their independence, that even though some of the newer judges are not necessarily inclined to approve as many cases as the older ones that we saw, and that the approval rate nationally has gone down some, I think that the idea of trying to get judges to approve fewer cases is kind of hit a certain brick wall. And I think that there's been some thought within Social Security, at least what I'm reading between the lines, is that Social Security feels that it's easier to fight down the road and get people off disability as opposed to preventing them from getting on in the first place. And the reason for that kind of makes sense, is that when people are applying for benefits, they can get an attorney like me. I'm paid on past due benefits. In other words, if somebody applies and then we have a hearing 3 years from now or 2 years from now, there may be 24 or 36 months of past due benefits. I get paid 25% of that, up to $6,000. So it's relatively easy to get an attorney to take a case on a contingency, because there's going to be 2 or 3 years perhaps of past due benefits, and I can take that case on a contingency. By contrast, when someone's already been approved and they get a notice of a continuing review, then there are no past due benefits, because they've been getting their benefits. That means if you want to hire me or hire an attorney, you're going to have to come out of pocket. And most people aren't going to have $3,000 or $4,000 to pay an attorney to come out of pocket for that. So what they're figuring, I believe, is that most people in the continuing reviews are not going to be represented, or at least not represented by attorneys. Maybe they'll have a friend or somebody like that come with them. I think that means that it's going to be easier for Social Security to cut you off. And it'll be more difficult for you to get an attorney. Now, whether or not there's some way that we can figure out how to get an attorney paid, we'll see how that pans out. But right now, unless you've got money saved away, then it's going to be hard to get an attorney to take a case, because there's no contingency. And of course, you're not going to find people who are going to do it for free. So what I would tell you is that, especially if you have a 3-year review, you want to make sure that, 1, you continue to go to the doctor. Number 2 is that you save your medical records. You make your own file of medical records so that you've got proof that you're going to the doctor. You've got those records that can be obtained. That you identify people who can speak on your behalf. If you tried to work, for example, an employer, maybe you can write an affidavit or a letter stating that you tried to work, you're not successful, a coworker, but you've got to really be proactive about building your case to protect your benefits if in fact you're not able to work. And of course, if you can try to work, certainly go ahead and try. Bear in mind that there's a 9-month trial work period you're entitled to, where you continue to get paid as well as collect benefits. But once you get beyond that 9 or 10 months, then they're going to cut your benefits off. So again, you got to be careful about those things. It's a very tricky time once you've been approved for benefits and you try to go back to work, and certainly worth a discussion with your attorney about what to do. But don't be surprised if we start to see a lot more continuing disability reviews, or CDRs, and that you're going to have to be going in front of judges or dealing with Social Security on your own, because it's going to be difficult to get an attorney to do it. So prepare yourself, talk to your attorney, get some advice about how to do this, but by all means continue to go to the doctor, keep your medical file together, make notes of people who can support you, and you may have to be fighting for to preserve your benefits if you cannot work. Although again, I've always found that unsuccessful work attempts can be very strong evidence in regular cases to get benefits as well as on CDRs. So that's just something to be aware of. Pay attention to it. Don't assume that once you're on benefits, you're always going to be on benefits. I think we're going to see a real move by Social Security disability to start cutting people off, and that can be quite disturbing, obviously, if you feel like you're not able to continue working and that you feel you remain disabled even though Social Security is trying to say that you're not. Hope this has been helpful. Any questions, please let me know. Again, my name is Jonathan Ginsberg. Thanks much, and we'll talk to you soon.